Thanks very much. Like our keynote speakers at lunch, I can say I did not pick the title of my panel, but unlike the keynote speakers, I can say that I very much love the title of my panel. And that is because most of the topics today and tomorrow, I guess, are broader than products liability and deal with regulatory issues and economics issues. And the FDA and some of the issues on the table might be risk or cost benefit. But in my much smaller world of products liability litigation, the issue is causation, true causation. And in the case law, they generally talk about causation as a two-part deal. That is, general causation, can the drug cause the adverse event at issue in the general population, and specific causation, did the drug cause the specific adverse event in the specific plaintiff who has brought the suit. And unlike in the regulatory arena, which we've heard so much about today, the plaintiff has a burden of proof on both of these parts in my world of products liability law. And it's a high burden because it's proof that it's going to be presented entirely by experts, and the experts are going to be meeting appropriate evidentiary hurdles, standards, as Elizabeth alluded to a little bit earlier, the feared Daubert challenge. And with all due respect to the last panel and Elizabeth, I've always thought that Daubert and causation were the hot topic, even while Levine was pending. I will limit my remarks to some general comments about what's going on with the admissibility standards, two specific areas where recent cases have answered or at least addressed some of the open issues, and two areas that I think we need to watch in the area of causation proofs. And one slide just to review what you already know, and the case that put the evidentiary emphasis on causation in federal court at least, of course, was Daubert. That's Daubert versus Merrill Dow, 1993, now 16 years old, and quickly followed by GE versus Joyner in 97, Kumho versus Carmichael in 99, and Weisgram versus Marley in 2000. And at a recent ATLA or plaintiff's bar convention presentation, the Supreme Court cases of Daubert, Joyner, Kumho, and Weisgram were described by one speaker as the four horsemen of expert testimony. And you may remember the four horsemen from the book of Revelations as war, famine, pestilence, and death. I'm not sure which of the Supreme Court cases gets to be pestilence, but in any event, I do agree with the sentiment that these are cases that matter, cases to be reckoned with. So just to go back to the requirements for a minute, and I'll just read them. Of course, Daubert said, and now Federal Rule 702 basically says, that faced with the proffer of expert scientific testimony, the trial judge must determine at the outset, pursuant to Rule 104A, whether the expert is proposing to testify to 1, scientific knowledge, that 2, will assist the trier of fact to understand or determine a fact and issue. This entails a preliminary assessment of whether the reasoning or methodology underlying the testimony is scientifically valid, and of whether that reasoning or methodology properly can be applied to the facts at issue. And the court went on to say that the subject of an expert's testimony must be scientific knowledge. The adjective scientific implies a grounding in the methods and procedures of science. Similarly, the word knowledge connotes more than subjective belief or unsupported speculation. The term applies to any body of known facts or to any body of ideas inferred from such facts or accepted as truths on good grounds. In order to qualify as scientific knowledge, an inference or assertion must be derived by the scientific method. And to me, and here I take issue with my panelists, I think that knowledge implies more than common sense. My main takeaway, just from this review slide, is that there is a lot of discussion about the amount of discretion that the trial courts have, and they do, in terms of how the inquiry works. The inquiry is flexible, but there is no discretion as to whether to undertake this review. And the issue of reliability is a hard and fast exclusionary rule. It's not a sliding scale. It's not a balancing test. The evidence is either reliable, scientific knowledge, or it's not. Now, just to justify our existence up here, since we're talking about a very old topic, I wanted to share some of this with you. These slides are not pharmaceutical specific, but of course pharmaceutical cases weigh heavily here. This is from PricewaterhouseCoopers' latest study looking at what they characterize as 3,681 challenges brought in federal or state court from 2000 through 2007. And of course, about half the states now are following the Daubert rules, and half are not. But looking at these numbers, the increases of challenges over that period, in 2000, they found 250. These are just published cases, of course, so the real numbers are probably significantly higher, but they found 251 cases, excuse me, and by 2007, they're up to 704 reported cases. I know just from a review of Westlaw that there are another 1,000 cases just in 2008 and 2009 so far that talk about Daubert, and a bunch of those, hundreds of them, are talking about Daubert in a very substantial, thorough way. So this is a huge issue, taking up significantly more of my time and undoubtedly significantly more of yours. And you know, to what end? Is it worth it? The answer is absolutely yes. If you look back at the published cases again, overall 46% of the experts were excluded in whole or in part, and 50% were admitted. Those numbers aren't matching up to 100%, obviously, exactly, because in some of the cases reviewed, the issues were still pending or the resolution was unclear. And if you look at successful exclusions only, in 2007, for example, 322 of the 704 challenges, 322 excluded in whole or part, and that is nearly 3 times, on an absolute basis, the number that was excluded in 2000. So as the number of Daubert challenges increase, so does the number of Daubert successes, and which suggests at least that these are not pro forma filings. They're important, they're worth the time and effort that are being spent by us and by you in the field. I think this is the last slide on that. The percentages have stayed relatively constant when looked at over the 8 years studied, so that overall courts have found that proffered expert testimony did not meet the exacting standards of Daubert almost half of the time, okay? Which means that if the Supreme Court got it right when it emphasized the risk and fundamental unfairness involved with unreliable expert testimony, the Daubert rules are incredibly important because proponents of unreliable science are out in the courts every day, all the time, in significant cases. That's why it's good to have causation as an agenda item, even for 15 minutes in a seminar like this. Now, the case law certainly is trending toward broad agreement, not perfect agreement, of course, that not all types of scientific evidence can support an admissible expert opinion. And certainly that is the case when only 1 or 2 types of evidence are offered. Even the gold standard epidemiology and case control study that Janet talked about won't necessarily be reliable if the expert, or form a reliable basis for an expert opinion if the expert is offering it in support of an opinion that the epidemiology itself does not support. But I think there is growing agreement in the case law and it's been referred to even as a tsunami of case law, that case reports, whether adverse drug events or published case reports, do not form a reliable basis on which an expert can offer an opinion. And the same would be true an expert who's looking only at studies in mice or rats to form an opinion about human causation. Epidemiology is not required in virtually all jurisdictions, whether the gold standard epidemiology or something less, but epidemiology is the best evidence, and in the absence of epidemiology, you have to look hard at the evidence that is offered, and that brings me to one of the specific areas of disagreement that is in the courts that I wanted to focus on. The first is, and that is aggregated evidence. And the courts have been somewhat split on the question of how weight of the evidence fits into the big Daubert, overall Daubert issue. My own view is that I think that was answered by the Supreme Court in Joyner, where the district court excluded evidence. The Court of Appeals reversed, saying that weight of the evidence was an appropriate methodology, and the United States Supreme Court reversed the Court of Appeals, sent it back, and said that the experts looking at the district court, looking at the evidence that the expert had proffered individually and collectively, was within its discretion to exclude that opinion. And in the pharma context, in pharmaceutical law, the best examples of cases applying that Joyner construct come from the Parladel trilogy, and Parladel was litigation in which plaintiffs claimed that Sandoz Pharmaceuticals' prescription drug, which was taken to prevent physiologic lactation, caused stroke, seizure, and heart attack in new mothers. And the plaintiffs relied on a whole slew of types of evidence, case reports, limited epidemiology, selective animal studies, chemical analogies, in vitro studies. And the district courts, which held Daubert hearings ranging from half day to 2 weeks, ultimately considered whether those experts could take the individually unreliable bits of evidence and pile them together to make something that was qualitatively more reliable. And those courts ultimately said no, they could not. And as the district court here in Illinois concluded, that simply amounted to a hollow whole of hollow parts. And the second area that I wanted to call to your attention, and this is the case that is on the website now and was left out on the table, and the case is Perry versus Novartis Pharmaceuticals, is a case involving specific causation analysis and differential diagnosis. This is not a Supreme Court case. It's not some extraordinary precedential case, but it is a case that's taken a hard look for the first time in a long time at how a differential diagnosis really works as applied in the Daubert context, because a lot of cases have let clinicians come in and say, well, I can't figure out anything else, I'll rule out other causes, therefore it must be the drug, and that's not a proper differential, as the Perry court made clear, because idiopathic causes or idiopathic issues in establishing causation have to be ruled out as well, or at least considered, when in most cases, in that case, childhood cancer, most of those cases have an unknown cause, and the expert has an obligation under Daubert to explain how it is that idiopathic causes or an idiopathic explanation can be ruled out. The two areas that I would flag for you as areas to watch, litigation-driven research is one. We've talked a lot about the pharmaceutical industry and how huge it is. Well, pharmaceutical litigation is huge too. It gets huge fast, and the stakes are higher and higher for the parties, and it is certainly within everyone's interest. The litigants want to defeat a Daubert challenge, and litigants now are extremely well funded, and it is in their interest to move proactively to get literature supporting their position out there. I mean, that's an unintended consequence, I guess, of Daubert itself, because Daubert puts the focus on peer-reviewed, published support for an expert's opinion. And I don't mean to suggest that that is necessarily a malevolent thing. It's just something to watch, because it's not always, you're not always aware that that literature is being funded by litigants in advance of litigation and while litigation is going on. We're seeing it all the time, and you have to have a great deal of discovery to display the unreliability that might be associated with that literature. The last item is a little bit more malevolent, and that is litigation-driven diagnoses. We've seen that a lot. This group was talked to, I know, about the silica MDL out of Texas. We're seeing some good discovery orders coming out of the asbestos MDL this year in Pennsylvania. But mass screenings of plaintiffs don't necessarily mean fraud, but it does mean the opportunity for fraud, and something that, again, we need to be on the lookout for, because that is the fundamental first step in the causation analysis. Thank you.
Thank you. Great.